Good afternoon, everyone. Welcome to, that was Michelle Stover saying hello. Yeah, it's always one. This is the 9th annual Thomas and Hafer Liability Seminar here at the lovely Hollywood Casino and Penn National Racetrack with the lovely view of the Blue Mountain behind the window blinds. Trust me, it's really nice when the blinds are up, but it's too sunny, I guess. At the moment, we have a fun-filled and fun-packed afternoon. Oh, no, that's down the hall. This is this is boring lawyer stuff. But no, I'm glad you all could come. This is very well attended, and we hope that you'll take something away. I have the microphone in my mouth because Drew, the camera guy there, said I had to do that because there are people on a webinar that won't be able to hear us if we don't speak right into the microphone. So if I look weird than normal, it's because of Drew, the camera guy. We are going to start out with part 2 of the crashes that most of you folks witnessed out in the parking lot before lunch. I was out there, and I have to say I was pleasantly surprised. I didn't think it was going to be quite so violent, and when it was more violent, I was really happy. And I think all of you share that sentiment. The people from Rimkus who put on that crash, thank you very much for doing that, folks. That was really fun. They're going to come in here and put it together in a more forensic way to show the physics and the math and the words that go with the crashes, and that'll take us till about 2 o'clock, and then we're going to take a break. For some reason, we have a break every hour for 10 minutes, which is fun because breaks are better than class, right? Then we're going to do emerging exposure and legal implications regarding opioids, vaping and e-cigarettes, and medical marijuana. It's the substance abuse hour, as we call it. And we're going to have some interesting observations about that stuff because, you see it in the news every day, and this will be a little bit about the legal implications of it. Then, after another 10-minute break, we're going to go back to what I like to call a biomechanical-orama, where we're going to have more biomechanical stuff. The first one's about cars. The second one's going to be about slip and falls. And a lot of you folks who are handling claims no doubt get a fair amount of auto accidents and slip and falls. And it's important to know some of these concepts and to know what the experts are going to say about certain things in evaluating the settlement value or the trial worthiness of any particular claim. So hopefully that'll be helpful to you. Andy Rentschler, who's a PhD in biomechanical engineering, is from ARCA, is going to be doing that presentation with some of our folks. Then another 10-minute break. Or actually, no, we're going to have a little bit on spoliation and preservation of electronic documents by some of our folks, and we'll talk more about that later, but it's a little part of the seminar on how to stay out of trouble and how you can get in. And then there will be a 10-minute break. I feel like I've been cut off. I got the hook already. So anyway, and then getting to the good part of today's program, after my closing comments, which you no doubt can wait for, at 5:10 there will be a social hour with beverages and some more food. No more chicken noodle soup, I'm sorry to tell you. But horse racing. There will be a Thomas and Hafer handicap race, and for those folks who want to go down to the paddock and get your picture taken with a jockey, you better start lining up now because it's the most popular part of this event. And I'm in every photo from like all 9 years, so this is your chance because these composites are collector's items. If you end up in the photo, you get a copy of it. Michelle Stover, who's quite vocal, is in all of them as well. In fact, you even got one on foam core this time, didn't you? Anyway, so we're going to start. Joe Cardile is going to come up, and he's going to do the first part of the tail end of the Rimkus thing. And he's going to introduce Dr. Leroy Waite, who's going to talk about the physics of non-injury. Oh, and I forgot to tell you, I'm going to get smacked in the head if I don't say this. We're opening up a Virginia office. January 1, and Lacey Kahn, who is amazingly wonderful, comes to us from State Farm, and she's a CPCU as well as a JD, like Michelle Stover. And so anyway, I think you're going to see her later, but I wanted to announce that because we're very proud of that. That's our 10th office, and TT&H is spreading to the south. Our competitors say like a disease, but we don't see it that way, and we hope you don't either. Thanks.
Thank you, Todd. Good afternoon. My name, as Todd said, is Joe Cardile. I'm an attorney with Thomas & Hafer in its Baltimore office. In a couple of minutes, I'm going to introduce you to Mr. Leroy Waite. Lee is a biomechanical engineer with Rimkus, and he's going to talk to you a little bit about what we just saw outside. Cars crashing into each other with live people in them. Those live people are still alive, and they're not injured. Let me jump to a little bit of background about how we came up with inviting Rimkus to come in here and put on its crash demonstration, because it's nothing new. Rimkus has done this for quite some time. About this time last year, maybe a little bit longer than that, Mike Burgoyne of our Baltimore office went to one of Rimkus's crash events and came back and said to me that it was impressive, and said I should go to it and maybe we should consider putting it in this seminar. So I went to it in June of this year, and I was impressed. It was cool seeing cars crash into each other. In the June presentation, I saw the impact car, or the victim car, had 2 people in it. And the car doing the driving had a driver. So there were a total of 3 people in there. None of them in the June seminar were injured. What was impressive to me about that event is that it answered a question that I've had for quite some time, and that I know that you as claims have had as well. These low-impact cases, these low-impact automobile accidents with no property damage or minimal property damage, but injuries, and then medical bills, and then really big medical bills sometimes. Last year I had a case that involved the plaintiff driving a large commercial van, one of those vans that kidnappers drive, the big ones, and he was rear-ended by a car much smaller than the cars that you saw out there. There wasn't a dent to the rear of his vehicle. There wasn't a scratch. How much do you think he had in medical bills? $187,000. Okay. I've got another one where the medical bills aren't nearly that. Guy's in a large F-150 pickup truck, hit by a car, rear-ended, much smaller than the ones that you saw outside. A dent to his truck. His brother's sitting in the passenger seat, the front passenger seat, 2 feet away from him. His brother's completely unharmed. The plaintiff, the driver, has $20,000 in medical bills. Okay. Why? No property damage, minimal property damage, big medical bills. Mr. Lee's going to talk about that. And Mr. Lee's going to talk to you about what you can do to defend against that, whether at the claims level or the litigation level. Maryland and Pennsylvania are very similar in their requirements for the admissibility of expert witness testimony. It simply boils down to whether or not the expert evidence will aid or help, depending on the state, determine a fact and issue before a trier of fact. So, without further ado, Mr. Lee Waite.
Take that. Good. Let's make sure everything works. Yeah, that's a good start. How about this one? Can we see our mouse? Okay, good. Thank you so much, first of all, for inviting me here today. I really enjoy getting in front of the classroom once again. You can see it's just the marketing people make me do this, right? I got to say, wow, who's this guy talking to us? And he doesn't seem to know anything. I mean, he doesn't know the difference between this and this. So, but my background is that I was a professor for a number of years, for kind of a long time, actually. And I was the head of a biomedical engineering department, and I was the president of the Rocky Mountain Bioengineering Symposium, and a senior Fulbright scholar at the University of Heidelberg. And I'm a registered professional engineer in a whole bunch of states, including Pennsylvania, including Maryland. So the continuing education people say, wow, you have to do good education. You have to teach something, so we need to do an outline, right? They make us do an outline. So we'll do an outline fast. Da-da-da-da. What is the low-speed collision? We're going to do the categories of collisions. We're going to do a little bit of human anatomy. Wow. For a whole hour, right, or a whole 15 minutes. And the medical guys, they take a whole class in anatomy for, probably 15 hours a week for a whole semester. But we're smarter, this group here. So we'll learn it all that we need within an hour. And we're going to do some videos of low-speed impact. So that's what you all really need to see. You got to really see. It was really good with the live crash. That's great. And it's really nice to see the follow-up, what actually happened. But to see the videos over and over and over, and we'll pick out some interesting things to watch in those videos. We're going to talk about commonly claimed injuries. You all know what they claim, right? They claim everything. People claim everything. But we're going to talk about what are the most common claims. And we're going to talk about correlation is not causation. That's an important aspect. And I got a case study. And we'll, as always, we keep an eye on the time and make sure we don't run over. First of all, what's the low-speed collision? Well, I mean, to some people, don't they think, well, to an insurance person, everything's a low-speed collision, right? It doesn't matter if your car is totaled and it's in pieces laying on the ground. The insurance guy is going to say that's low speed. But we say, we're talking here when the delta V, that means change in speed, is less than 8 miles per hour. You can see engineers made this up, We shouldn't have said delta V. We should have said change in speed, right? It's just, it's one of those things that engineers have deeply embedded in them that they can't think of change of something without thinking of delta, because that's all those equations they ever did. They got to use Greek letters. We're going to talk about a delta V of 12 miles per hour or less if it's a front-end collision. Oh, in a front-end collision, you can do more. And if you get a chance to practice these a lot, you'll find out, getting hit from behind, that's maybe less fun than the ones where you get to hit somebody from the front, right? You say, okay, it's 12 miles an hour, we're going to really crash into them good. Okay, and the categories, we're going to do rear-end collisions here, frontal, T-bone, side swipe. It's hard to set all 3 or 4 of those up for a short demonstration, right? But we can show videos of everything. First, we got to talk about anatomy. And so you got to tell your boss, I actually did learn something, right? We learned that there were 29 bones in the human body. Sometimes I gave that talk and the people came to it the next year. They say, 229. So then you say, okay, there was one thing we learned anyway. But all the ones that are named there are kind of most of the ones most of us know names about. We've got a nice model of a spine here. We're going to show spines and talk about spines. Why? To you guys, because that's what people claim. They claim lumbar herniations, they claim cervical herniations, and they all claim, I didn't have any back pain at all before the day of that accident. So we're going to do a little bit about the... Did I just lose? No, it's there. Anatomy of the spinal column. We're going to talk about the fact that there's a cervical spine with 7 different vertebrae. We're going to talk not so much about the thoracic spine. Why? Because that's pretty flat against the back of your car seat. And people also don't get so many problems with the thoracic spine, so they don't claim those as much. But if they do, it doesn't have anything to do with their car crash, right? Because their back is flat up against the back of the car seat. You want it straight? Does that one still work? Oh, great. That one works too. Okay. How about we're going to talk about some things like I wanted to say here about this median atlantoaxial joint, the one that's up at the top of your spine. That's a kind of a cool one because it makes it so you can shake your head up and down. You can shake your head side to side. You can rotate your head also that way. It's not simple to figure out a good way to make that all pivot together. The atlantoaxial joint. But kind of where the crux of it today is, why do people claim these disc problems? Well, think about what's going on here. You've got in between your vertebrae, in between each of these bones here, here's a big stack of them. The thing that looks like a white plastic thing here, that's this vertebral disc. And that vertebral disc is making it so there's a kind of a cushion, and so one part of this can rotate on the other part. And what I'm going to do also now at this point, I'm going to take this little model, and it's a model of a disc herniation, this little red thing. Just pass it around. Everybody can look at what that kind of two vertebrae looks like, what a disc looks like. But here in this picture, think about this disc. How does that change as you age? Well, guess what? You get a young person, they have these normal-looking discs. As you get older, some of us get somewhat degenerated disc. They look like they're kind of dried out and cracking. You can get a bulging disc where some of the stuff is coming out the back. Well, think about this. Think of that disc as being like a jelly donut. It's got in the middle of it, it's got some important stuff. It's not really structural. But around the middle, it's got a part that's pretty strong to hold all the stuff inside. And when you eventually break through that strong stuff around the middle, around the nucleus of your disc, when the jelly comes out of the jelly donut, that's a bad thing. That can push on some nerves, and guess what? It's your spine, right? You got this big nerve going up and down so that you can have you have neurons going out to your legs and arms. And so anything going on in there where you got something pushing on nerves, that's going to turn out bad. But it happens to a lot of people who don't have car accidents, right? It's part of aging in some ways. The good news is not everyone gets this. It's asymptomatic in most of us. But if you look at an MRI for people over 45, there's something like 80% of them have something on the MRI that you could say that's a defect, a spinal defect. Guess what? When you get to my age, it turns out 95%. Good news again, we don't all have bad backs. Knock on wood. And then, so you get those thinning discs, herniated discs, disc degeneration. A lot of times, guess what? You look on the MRI, they've also got osteophytes, this kind of bone growth. That's part of degeneration. That's not, you didn't grow those extra bones during that car accident. That doesn't make any sense. But people claim everything. So here it is again. Somehow the herniation is pushing on a spinal neuron, and that's going to cause big problems. There's one on an MRI. You can see what it looks like. Actually, I have a pointer here. Look at that. That even works here. That's good. On modern screens, a bunch of them, you can't use the pointers. Did you notice that? But this one works good with the pointer. Okay, let's go on. So here's the videos. This is the good stuff. Part we got to get to. Okay. On the rear end collision, here's what I want you to watch for. I want you to watch which way does the driver move in a rear end collision. Every single person will testify. I was hit from behind, thrown forward. And I give them that. I say, okay, because he's thinking about the bouncing off the seat. You do go forward when you bounce off the seat, and you do go forward in a certain sense because they hit you from behind, they push you forward. That's kind of true. With respect to the interior of the car, first you go back, then you bounce forward. I want you to look at that, see if you can see it. I want you to say, does he hold onto the steering wheel? Can you hold onto the steering wheel? And does the seatbelt engage? Can you see that? Let's have a look. And I might have to come over here on some of these to make sure they run. Here we go. Let's try that one first. Okay. That one you probably need to see in slower motion. By the way, look up here, 4.5 mile an hour impact velocity, a 3.0 change in velocity. So you say, okay, that's not a big one. But let's look at it in slow speed. Does he go forward? Does he go backwards? Whoop. I'm going to do that again. I think I messed it up by clicking the wrong way. There we go. You can see it now. Which way does he go? He goes backwards with respect to the interior of the car. Then he bounces forward. At that low speed, this guy, Rusty Height, he loves sitting in the car and getting banged into. He did that all the time, and he can hold onto the steering wheel because he's done it a lot. Most of the time, your hand just kind of flies off. At low speeds, you can hold it if you're trying. Okay. Go on to the next one. Does he go? Which direction does he go? First he goes back, then he bounces forward. That one he kind of held onto the steering wheel. Watch for the seat belt and see if you can tell if it grabs him. It needs me to click. In that case, even for this relatively low speed collision, you can see what's happening there. Sometimes I'm going slow because I'm not sure if there's another video right behind the first one. There we go. Let's go. I got to look up here to make sure we're... There we go. This one, look at this. Impact velocity, 6.7 miles an hour. So it's a little bit more. But the delta V, the change in speed, is still only 4.8. The door's off so you can see a little bit better. Holds on to the steering wheel. He bounces off the seat. He first goes back, and the seatbelt grabs him. Notice that this one has an impact velocity of 14 miles per hour. That's an 8.3, so that's just above what we would call a low-speed rear-end collision. It's still a volunteer. Rusty was not injured. Let's see it in slow motion. But look, now you got to worry about the seat bending. What if Rusty was a 300-pound plaintiff? Then the seat bends a lot, right? And you might slide up on it also. And there's some other things that happen in that regard. And this one, even Rusty wasn't able to hold on the steering wheel. And here's super slow motion. He definitely goes backwards with respect to the interior of the car. Definitely can't hold on the steering wheel, and he definitely gets caught by the seatbelt here. Okay. this goes to show that even when you do things and you plan it out carefully, it doesn't go right every time. Did you notice that that in the bullet car here, we didn't really plan for the airbag to go off, right? She just got a little bit over enthusiastic about that, but it's all good. You know, it turns out nice anyway because the airbag went off. We have another one with an airbag later, and you'll see it's not a terrible thing when your airbag goes off. So let's go on and see. So here's what we're trying to say with this one. This is a complex-looking slide that says, oh yeah, the Vericom, that's a device inside the car. So then we know how fast it was going and how fast the change in speed was. Such a special accelerometers inside the car that can measure that. That's how we know it. But then there's another thing that we say, oh, from one car and the speed of one car, like let's say you have a plaintiff and you have a defendant and there's two different cars. If you get the speed from one of the cars, we know the speed from the speed of the other one in the delta V calculation because that's conservation of momentum. So from conservation of momentum, if we know that this one is going 6 miles per hour, then it comes out at delta V 8.3 over here. And here we measured it as 12, and it comes out at 7 mile per hour delta V. So this is not plus or minus 1 mile an hour. You really, it's at the limits of the measuring devices, but we can do a good job. It always depends a little bit on the coefficient of restitution. That means how bouncy the car is. If some cars are bouncy like a Super Ball, other cars are bouncy more like a big glob of putty, and so they're different, and that's going to change the calculation. But let's keep going on these. So now we're going to have some frontal collisions. In these frontal collisions, on this first one, how far does the target vehicle move on the pavement? So say a lot of times you ask the defendant, how far did the car move? And they'll either say, oh, I don't think it moved at all, or I think it moved 40 feet. Really? You were on the other side of the intersection after that person backed into you, hit into you. Oh, I don't think the other side of the intersection, but a long way. Anyway, so they're trying to remember. So does the target vehicle move on the pavement? Which way does the driver move? And then we have a nice airbag here. And I want you to look and see, does the airbag hit the driver? Does it hit him in the face? Does it smack him? Does it look like it hurts? First. So it's a frontal for the bullet car, right? It's a side T-bone kind of for the target car here. Here it is again. Did it move? Yeah, there's a definite delta V. That car was going 0 sideways, and then it was going something sideways. It moved some distance. Easier to see from this point of view. Maybe 3 feet, right? That's the fan going. Not good for the fan to have that frontal collision, it turns out. Okay. And here's my good friend, colleague, Tassos. He's in that car. And he looks like he's not like worried or something, but he's not really. It's just that's the nature of photography, right? You caught him at a bad time. He's almost got his eyes closed. He's thinking about those Miata airbags that shoot shrapnel into people's faces. You know, I guess he's thinking about something like that. So I hope I don't have one of those. No, he didn't have one of those. How about it? Did the airbag hit him? Not in the face, and this low speed, well, it has to be a little bit higher speed to make the airbag go off. But even so, the seatbelt grabs you before the airbag hits you usually. It doesn't look painful, did it? Okay, keep going. I got to click on these to make them run. Now these are the T-bone. Boom. So you see what happens? It kind of slides. And what do I want you to see here? I'm saying look and see which way does the person go. So if if you say, oh, the car hit me on the right side, and therefore I hit my head on the driver's window, it doesn't make sense, right? Watch them. That one happens a little fast, so watch it in slow motion. Which way does his head go? I promise you, every single time, Isaac Newton, if you were here, he'd tell you this. Every single time, you're going to go in the direction of the thing that hits you. When it comes toward hit you on the left, you're going to move to the left. Now, when you have a seat behind you, you're going to bounce off the seat, and then you have the feeling that you went forward, right? But in these kind of things, there is no bounce. Nothing's going to bounce you into that window. If they're hit from the right, you're going to the right. If you're hit from the left, you're going to the left. Keep going here. And one of the things they're trying to show here is if you're pretty close to the center of gravity of the vehicle, to the middle of the vehicle, the middle of the center of mass, if you're pretty close to that, it doesn't want to spin so much. But in these collisions from the side, it'll want to spin. And look at that. It's a impact velocity of 7.7 miles an hour, the delta V 2.9. So when you're getting down to those 2 and 3 and 4 mile an hour delta V change in speed, there's really not much happening there. Now we're going to talk about side swipes. Oh, these are my favorite, because then you can say, oh, guess what? Side swipe, there's no delta V. Watch. Here's a side swipe just to show. Oop, I forgot to run the video. Let's do it. That's exciting. Oop, got to click on the next one. But if this were some guy in the parking lot at the post office, and you do that, he'll tell you, I'm fine, everything's okay. But 3 years later, there will be a lawsuit. Not all people, right? It's a very small percentage of people who do those lawsuits, right? That's my impression, at least. It feels like everybody does it to us because we see them all the time. There he goes. And you see look at the driver compared to the car going past him. It's nothing. He doesn't feel anything. There's rocking on the suspension. That's all it is. We've got a couple more side swipes coming up here. Okay, I like this one. See, this is my recommendation. If you're in this situation, don't get out of the car. Stay in the car. Aren't you glad you got an expert to come and tell you that today, right? Because you stay inside the car, bang. It's not good for the door, but it doesn't cause any trouble. So here's from inside the car. Being inside the car, you don't notice anything at all. And here is my good friend Richard Broad in the vehicle. It sounds terrible, right? And the repair bill is going to be phenomenal because it costs a lot to fix every panel on the side of that car. But is there any crush to the side of the car? No. Is there any delta V? Well, let's look. Here it is. Here's the accelerations in G's measured inside the car. You say, wow, maybe he accelerated so hard that he hurt himself. But the acceleration, 1G, is what you all are feeling sitting on this chair. You need 1G of, it's hard to talk about 1G of force because I'm a professor. I don't talk about that in that way. But in normal terms of what you think of as 1G, that's the force that's pushing against the bottom of your seat, holding you in place. And so you don't accelerate downward at 1G. And so here we have accelerations around a half a G, from side to, and basically that's just from the thing rocking on a suspension. You're just kind of bouncing back and forth. How about the delta V of the Cavalier or the Toyota, either one of them? 0. There is no delta V. There's lots of research, lots of studies. They put lots of people in the cars. They hit them with big trucks, with little trucks. You hit them with everything. If it's a side swipe and there's no significant crush, it's 0 delta V and there's no chance for injury. Another more literal interpretation of the phrase to blow the doors off. You can't see the doors very well because it's in the dark, but you'll see them here. The doors are open on this car, both doors. Whoop, go back. My mistake. You got to click this guy. There it goes. Boom, boom. Okay. Didn't look like a big deal, right? Here's the crazy person driving the car and say, wow. And part of this is that I want to be able to sit in front of a judge and jury and say, no, I've done this. We do this once a year or something. Tracy does. We all do that. And it's not a big deal. Whether it's the 2-mile-an-hour kind of collision. And so, and they gave me that really nice headdress to wear. They like that nice blue accelerometer, kind of in the latest styles and fashions. So here comes the guy, madman driving. And watch the window. Do you see why it's a good idea to keep your windows rolled up? Because if you don't, the mirror you just knocked off the car comes right behind your head. And that happened to somebody in our group one time. It wasn't me. I'm smart enough to roll the window up because I heard about the other guy. Okay. And so, what does the car look like afterwards? It looks kind of like that. It's not good for the doors, but it's no problem for the people inside either vehicle. Look at this, though. This is interesting. And look at the target vehicle. It had maximum Gs, maybe up to 2 in one direction, minus 1.8, 1.8. But look at the large Gs on the bullet car occupant. What's that about? How come we had such large accelerations? Where was the accelerometer? It was on my head. Did you see the picture of what I did? And you duck at the last instant and go ahead and try not to do it. I said, I'm not going to duck, man. I can do this. I won't do it. I won't even blink my eyes. Yeah, good luck. It wasn't me. I blinked. I ducked my head. So what about, this is the point about I'm not really allowed to question medical opinions. That's not what I do. I'm not an MD. And I would never question some doctor's opinion of his judgment. Sometimes I wonder about some of the things they diagnose, but we leave those medical opinions to the physicians, and we would be happier if they leave the engineering opinions to we biomechanical types, because we know something about causation, for example, in the mechanics of the incident. And so you all know about the doctor who broke his arm. He fell down the well. And the advice that we gave to him was that physicians should tend to the sick and leave the well alone. It's important to have people laugh at it. It's a really stupid joke one time through the presentation. I learned that from being a professor. Okay. So I want to tell you also, see how we're doing on time. Perfect. Correlation is not causation. And this is the American Medical Association. It prints out a book on causation. And we offer that book to our clients, and well, to you all, to anyone who would ask me, say, oh yeah, here's the causation book. And in that book, They tell physicians, oh, don't make that mistake. Don't think that temporal correlation, that is time correlation, is related to causation. Just because the rooster crows in the morning, that's not what causes the sun to come up. I mean, maybe it is. I never really did the research on the sun coming up thing, but I'm guessing it's not the rooster. And there's a whole bunch of other things. It's a guide. It's a post hoc ergo propter hoc. After this, therefore because of this, it's a logical fallacy. And you all can think of several examples of that. I think we're a little bit on time press today, but in the ones where I have plenty of time, I would say, take 2 or 3 minutes, talk to your neighbor, and think of this kind of a fallacy that those things are unrelated. And I'll just jump right to my favorite one. How about, everybody knows here, because your mom told you, your grandma told you, somebody told you, don't go swimming after you eat or something like that. It might be okay. You get a cramp. Who knows? But how about this one? You should never go swimming on days when you eat ice cream cones, right? Right? You all know that, right? Because just think about it. There's a strong correlation. Drownings are strongly correlated to ice cream cone sales. And so what's the logical fallacy? You got to say, well, they are connected. They're definitely connected. But what are they connected by? Temperature, right? Summer, the season of the year. And so on the days when you sell the most ice creams, that's the days when you get the most drownings. So never, never, never let your grandchildren go swimming and have ice cream cones on the same day, because it's really super dangerous. Strong correlation. No, I'm making jokes. It's a fallacy. It's a logical fallacy. And you can think of a million of these things. It's the movies that, somebody starred in with Kevin Bacon, or there's always some kind of correlation with something, but it's not truly causation. And the American Medical Association warns doctors about this. But sometimes that's all the information they have. They only have the information that their patient gave to them. So commonly claimed injuries, not really tripping over anything here. Strain and sprains. I'm always amazed how these things start out with strain and sprain. They're always diagnosed, and I'm thinking, well, it's okay. There's not a big loss from sprain or strain, right? 2 or 3 days later, a week later, you're pretty good. But wow, do those digress into hundreds and thousands of dollars of medical treatment. Then bulging discs. That's what I'm saying. We've all got them. Not we all have them, but a huge percentage of them, of us, have those. And it's better sometimes you don't know that you have that, because that's just a normal part of getting older, that sometimes you have a bulging disc. I think I have one. I'm not sure. How about traumatic brain injury? Did you ever hear anybody claim that from a low-speed car accident? Same kind of problem. Torn rotator cuff. How about that? I ended my pitching career. I thought I was going to be able to pitch for the Phillies later, but now I got that torn rotator cuff, and it's all because of this one accident. Torn knee meniscus. That's a really common one that we see. And carpal tunnel syndrome. It just makes me sigh sometimes. Carpal tunnel. That's not even sometimes to me as bad as the tennis elbow or golf elbow. You got tennis elbow or golf elbow, quit playing golf or tennis for a while. Just take a break. You don't have to quit completely, but just don't do it for a while. But they say, no, I have this lateral epicondylitis, and it's related to this 5-mile-per-hour crash. Injuries are caused by either contact. So we say, it's a good idea. And many attorneys ask that in the deposition. Well, did you hit something inside the car? Did your head hit something? Did your body hit something? Good idea to ask that. And then the other thing is exceeding the normal range of motion. You can have a kind of a thing where you didn't really have a really hard contact, but your arm went so far because it was pushed back that caused some kind of a trouble. in the injury in the 3 mile per hour or less, there's no potential for injury. And how do we know this? We know this because up to 5 or 6 miles an hour, I'll happily sit in the car. And we do this with a lot of volunteers. And there's a lot of studies out there that show you don't get injured at this is being really conservative by saying 3 miles per hour. Greater than 5 miles per hour, you risk cervical strain. Greater than 8 miles per hour, now you're going to risk having a lumbar strain. In the frontal collision, less than 7.5 miles per hour, nothing. That's why it feels good. Bang. You know, you hit the car in front of you. You say, oh, let me do that. Let me drive today. I want to do that. It's not a problem. With the frontal ones, you can go pretty fast, and you don't have any risk of strain. Greater than 12 miles per hour, cervical strain. And remember, this is a change in speed, an instantaneous change in speed, where you're driving along 12 miles an hour, bang, you hit something, and that over let's call it 1/10 of a second or something, 100 milliseconds, that's the length of that crash. And over that length of time, that really, really, really short length of time, suddenly there's a change in speed of the car. That's what delta V is. And in the T-bone, those are more complicated to have hard and fast numbers. It depends on which side, and did you hit on the door or did you hit farther away? Side swipe, unless something's hanging out, there's just no real reason for getting injured. Here's the thing we have to be careful about. I'll look at something and think, oh, that's a side swipe. But be careful, because sometimes things that you thought were side swipes, they look like side swipes, but you see, oh, but he hit the back corner of the bumper or something. There's some perpendicular surface that makes it not a pure side swipe. But if it is a pure side swipe, then there's no reason for injury. No mechanics. No mechanism there to cause an injury, unless there's some kind of intrusion. You break through the windows and something from another car sticks inside the car. Yeah, okay, that's different. How about some useful information? What do you give to us? I'll call you. You call me and say, oh, Dr. Waite, we've got this really nice case I'd like your help with. Say, okay, we would like to see the police report if there is one. A lot of times there's not one. How about the repair estimates for the vehicles? We'd like to see pictures of the vehicles. We would like to see some witness statement or a deposition or transcript or recorded statement, anything, because sometimes the plaintiffs will even be their own worst enemy in the sense that they'll tell the truth, and they'll say, well, no, I didn't really see damage on that other vehicle, or I didn't really see this, or I didn't really see that. So some of the things, we can get just from a direct transcript of a recorded interview. Medical records, and usually when we say imaging, we're really talking about we'd like to see the reports of the images. I'm not an expert at reading radiographs or MRIs, so I wouldn't really go through the images themselves. We'll try to make this so it doesn't sound too much like a third grader wrote it, but at the same time, we want to make it kind of so the jury can understand it, so you can understand it. There's some fine line in between, well, you don't want this report exactly so every juror can understand it, but you want to first make the report scientifically correct and accurate, and so that my client can understand it, but then we want to be able to explain it so that the jury can understand it. We'll do a written report. Sometimes we just do a letter report, a report of the conclusions. We can do a really less expensive version of that. We can help out with the demonstrative evidence like videos and all kinds of things, posters. You guys don't need coordination with the attorneys here, right? It's the wrong group. Okay, and testimony. That's what we do for a living, right? And eventually it comes to a case where it comes to a trial, and they want me to go and testify. And here's the case example. How are we doing on time? We're okay. First case example. Claim is traumatic brain injury. And basically, here's what happened. A 2012 Chevrolet Impala driven by IM plaintiff was stopped to make a left turn. A 1994 Subaru Legacy driven by insured was traveling behind the Chevrolet when the front of the Subaru contacted the rear of the Chevrolet. Mr. Plaintiff claims that he sustained a traumatic brain injury in this incident. So you see the terrible crash that happened. You see the damage to the back of the Chevrolet. You say, wow, no wonder he got a TBI, the terrible damage to the back of the car. So the photographs of the Chevrolet revealed scuffs on the rear bumper cover, which was subsequently replaced according to repair estimates. So, we look at that and we'll look at the repair estimate and say, did they replace the bumper cover? And they did, because it has a scratch. Did they replace the energy absorbing material? They didn't in this one. Did they replace the impact bar? No, not necessary. Nothing was damaged. And you say, okay, that wasn't a hard Delta V. It was in the range of 5 to 8 miles an hour. And we're being super conservative here, because you got to say, I'm going to swear on a Bible in a courtroom that it was not more than 8 miles an hour. So we're really, really conservative. It looks more like it was 2 or 3. So in this case, the studies of low-speed rear-end collisions have showed that the occupant's peak linear head acceleration is 2 or 3 times the vehicle acceleration. So you have to realize that. He's going to bounce around in there, and he accelerates more than the vehicle itself. Damage to the 2 vehicles in this incident indicate a linear head acceleration of less than 15 Gs and an angular acceleration less than 650 radians per second squared. And while that doesn't mean very much to you in just numbers, when you put it on a chart like this and you say, here's the linear acceleration, and here is rotational acceleration or angular acceleration. And where do we get those numbers? That's in a published paper where they do this. They're studying concussions with football players, and they instrument a whole bunch of people through a whole season and see what kinds of accelerations can cause concussions. And when you're playing football, yeah, you see accelerations, right? Some pretty high ones and sometimes some pretty low ones. And so here's 1% chance of a concussion when you have 40 Gs. And maybe, depending on what the rotational acceleration is, maybe it was high. So we're not really sure here. 1%, 5%, 50%. How about down here at this little red dot? That's where this incident was. Can we say impossible? He could never have a concussion. No, we say it's really, really, really unlikely. It's a 1 in a million chance or something. And so that's the problem with concussions. There's no really easily definable lower limit. And there's a whole bunch of RMCA's places all around the country. I don't need to show you guys all those. Kim Trieschman is out here somewhere in the back, and there she is back in the back. She's got her hand up, and she'll tell you every place if you want to know where a RMCA's office is. You see some other people. I think Tracy's going to come up and take over with the information about how the crash that you all witnessed turned out. What do you think? We show a poll, 5 miles an hour Delta V, 2 mile an hour Delta V, 1. We're in good shape time-wise.
All right, real quick, I'm Tracy Jones again, if you guys remember me from outside. First, I want to give props to Joe Washington. Dr. Washington was the driver. Can everyone give him a round of applause? And then Josh Slippy back there is from IAA. thank him again, because without IAA, we wouldn't have those vehicles. So, all right. So now we're going to talk about the actual crash test. So Dr. Waite was talking about low-speed crash tests, and that's what we simulated out there. So I know it wasn't as much fun as 50 miles per hour, but, next time. So here's our first crash test. So, and I'm gonna zip through it. I couldn't cut the clip, so I didn't have time for all that.
That's what I mean.
Should be coming in here pretty soon. So we had a pretty good clip, pretty good hit there. The GMC, the striking car that Dr. Washington was driving, actually had an airbag control module that records. How many people know that there are black boxes and airbag modules record? It makes life a lot easier, because in 2012, NHTSA made a rule that if you're recording, you must record this, this, and this at this change of velocity. The change of velocity they stated was 5 miles per hour. So if there's a frontal impact, rear impact, or side impact that results in a change of velocity of 5 miles per hour or greater, it must record. So if you get no recording, guess what? It was less than 5 miles per hour. Great information, right? So if you think, oh, I didn't get a reporting, it's not worth it. Well, it is. So in this one, here is the download. And look, our change of velocity. Dr. Washington's change of velocity was negative 4.6 miles per hour. So he's fine, right? He's walking, talking. He's only going to take about 2 months off. Okay? Negative means it's a frontal impact. If it were positive, it would say a rear impact. Or if it were positive, that would mean rear. So then we go to the pre-crash data. This is all the cool stuff for us reconstructionists, because, hey, I don't have to do any math. It tells me how fast he was going. Isn't that cool? Actually, still have to do math. So anyway, he accelerated up to 16, got down to 14. The 14 is within 1 second of impact. He was doing about 14 at impact. But his change of velocity was negative 4. What does that mean? It means he came in at 14, he'd lost 4 miles per hour, and after the contact, he still, in braking, lost that last 10 miles per hour. Does that make sense? That's what a change of velocity is, the change of velocity in the crash. So the crash took away 4.6 miles of his speed, but he still had to lose the rest in braking, which he did. So you can see where his brakes on and off, and you can see his percent throttle up there. Okay? So if his delta V was 4.64, we can use math to calculate the delta V on the Suzuki. So the Suzuki weighs less. All we got to do is get the weights for the vehicles, and I averaged off. And we do a little math, and so the Suzuki sustained a delta V of 6.6 miles per hour. Okay? So still not a bad crash whatsoever. So if someone's in the Suzuki, I would not expect any kind of injury. But I'm not allowed to say that. They have to say that. So here is our side swipe now. So this is one view of the side swipe. We got some pretty good engagement. And you see, he angled it a little, so you got a little more than the suspension really rocked. But still, if you're in a rocking suspension, are you going to contact anything? No, you're just going to rock in the seat. So then we have the aerial one for this one too. So it comes in. It's a little buffered there. But you see, it moved that Suzuki just a little bit to the side. And it was a little more than a side swipe there, but still. So our accelerometer from the iPhone calculated the G's. It was calculating G's, and it gave me a time stamp, and it gave me G's. And I can use some math and some big math called integration, and I can calculate the delta V from those G's. And its delta V was 2.01 miles per hour. Is that anything? And that's in the Suzuki because the accelerometer was in the Suzuki. Okay, and the reason it is even that high at 2 miles per hour is because he really did engage it a little bit more than a typical sideswipe. Any questions? Comments? That's my 5 minutes of fame.
Thank you, Lee and Tracy and Joe. It's very informative. Let's take our 10-minute break. You're not that interesting. Hey, just a little housekeeping before we get on with the substance abuse portion of our program, at the end of which free samples will be handed out. And then we're going to have you drive the crash test cars in the parking lot. These presentations qualify for 3 CE credits, continuing education credits for Pennsylvania insurance adjusters, and 3 continuing legal education credits for Pennsylvania lawyers as well. And Tony was handing out the forms outside. If you want to fill those out and turn them back in, we'll turn them in for you and get you your credit, or you can take them with you, your choice. But if you are eligible for credit, please make sure you get those credits because they're not really easy to come by. You don't want to pass up the opportunity for 3. The next presentation is by Josh Bovender, who's a part on opioids. Peter Bieberstein is a lawyer in our D.C. office on vaping, which apparently is more dangerous than anybody thought originally, if you listen to the news. But I don't want to steal Peter's thunder. And then Rebecca from our Pittsburgh office will be talking about medical marijuana. And I was telling Pete Speaker on the way over here, I drove him over, and I said, Pete, I've been feeling some anxiety lately. He said, oh, man, you can get medical marijuana. Why didn't you tell your doctor when you had your physical yesterday? I'm like, yeah, I wish I had thought of that then. But no, I'm an advocate of clean living, as I'm sure all of you are, and enjoy the next presentation.
Thanks, Todd. My name's Josh Bovender. Like Todd mentioned, I'm in the Harrisburg office, and I don't have a pocket watch, I don't have a monocle, and I don't know if when you pass go you can collect your $200, so stop asking. Hurtful. Opioids. Yeah. So I'll set the context first, and then I'll talk about it. What we see a lot of is very modest claims get a new damage roped in with them. Okay. This doesn't sound like it's on.
All right, well.
Can you hear me?
No, can you hear me? Can you hear Josh?
Can you hear me now? Here's the context. Very modest claim comes in, and what you have is an opioid damages claim. Very vague but common, for example. Low speed rear end collision or a very modest premises fall with some very modest injury. And then in the case, somewhere down the line, the claimant gets prescribed under a valid prescription some sort of short-acting analgesic, narcotic, opioid, whatever we want to call it. And then part of their claim in the case is they have either an addiction, an abuse issue, or a long-standing prescription for pain management drugs that they're trying to relate to your claim. And that's what this part of the segment talks about in the 16.6667 minutes I have to describe it to you. So, Todd mentioned earlier about the headline. I wanted to talk about the headlines, and this stuff gets a ton of national media attention. And when we talked about this recently at the CPLCU presentation, or I may have gotten that acronym wrong, Heather Arnold knows it already, so you can just tune me out because you've seen it and heard it. It's really weighing in on juries' consciences and deciding how juries view, react, and award damages based on opioids, because every day they're seeing headlines about bad folks doing allegedly bad stuff with bad drugs. And so we wanted to talk about it. And so what I'm going to talk about largely is a little bit of the statistics. I'm going to skip over some of this stuff and get into the blame game, because some of the larger outfits in the country are being blamed, and perhaps rightfully so, for a lot of the issues that's going to guide your juries when these modest BI claims go to trial. And this is across multiple lines. This is also in workers' compensation. This is also in personal and commercial. It covers a lot of lines. So has anybody, let me talk most recently, moved backwards? Big pharmaceutical companies in the news. Did anybody catch the amount earlier this month that Johnson & Johnson got hit with and the Risperdal in Philly County? $8 billion. B as in boy, billion. Now, granted, that was a Risperdal drug. That's not an opioid. That's not what we're talking about. But the issue is the same. This theory that big pharmaceuticals companies are hiding things, that innocent people are being prescribed those things, and those innocent people are suffering bad results. The Risperdal lawsuit that Klein Spector had out in Philadelphia County, it was an antipsychotic drug that was being prescribed to treat, among other things, autism, and there were bad side effects. Young boys were growing breasts was the main side effect from the antipsychotic drug Risperdal. And that's what resulted in the $8 billion verdict. If you go a few months back, has anybody followed the Purdue Pharma settlement, or what's been proposed as a settlement? I've got questions on this, and what I'll do is give you the Reader's Digest version on what's going on in that settlement, because your jurors are listening to it, and that can give some weight to the claim that some otherwise healthy person has a serious injury that resulted in an opioid addiction. So by way of brief background, Purdue Pharmaceutical is a privately owned company out of Connecticut, and they are the main manufacturer, actually the only manufacturer, of OxyContin, which is oxycodone, which is about 7 times stronger than morphine. And the genesis of this thing is in 1996. They start manufacturing the drug. Early 2000s, there's some bubbling up rumors that they may have known how addictive this stuff was, but not told the doctors who were prescribing it. Fast forward to 2008, several executives from Purdue Pharma are charged. And fast forward to August of this year, there's about 2,600 lawsuits pending against Purdue Pharma. They are part of a massive multi-district litigation, which is being handled mainly in Ohio. And there is a very big settlement on the table right now. And that settlement, which is going to potentially alleviate Purdue of all liability, is getting a lot of attention, and perhaps for good reason. So here's the proposed settlement for Purdue that is in the headlines that jurors are hearing about. First, Purdue Pharma is part of the settlement of these lawsuits brought by several attorney generals from, I think, 47 different states. First of all, is going to pay into a fund to the tune of $8 to $10 billion over the course of 15 years, monies to go back to the states to reimburse them for all the funds they had to expend to deal with the opioid addiction crisis. So, not that bad of a concept, except for 2 little things. First of all, the Sackler family. I don't know if anybody recognizes the name Sackler, but according to Forbes, they're one of the 20 wealthiest families in the country. They're the family that owns Purdue Pharma. They have personal liability in the case, and that family's been personally sued. And the theory is the Sacklers have actually, once they caught wind of what was happening to their company, grabbed about 10 to 13 billion, B as in boy, billion, dollars from the company, pocketed it, and then offered up the company on the chopping block as part of the settlement. That's issue number 1. Issue number 2 is the rest of the funds that would fund this settlement are coming from a drug that Purdue or its successor entity will manufacture to help treat the addiction. Why does that cause a problem? Well, the company alleged to have caused the addiction is now going to be profiting from the drugs to treat the addiction and use those profits to fund a settlement to deal with the liability from the addiction itself. Kind of an issue. So, this isn't specific to Purdue Pharma. There's all sorts of different big pharmaceutical companies that have very similar issues. Purdue in particular has caught the headlines. So, the reason I bring all that up is because the jurors are aware of it. It adds teeth as a part of the social or cultural ethos to a claim that some innocent driver who got rear-ended at 11 miles per hour, got a script for OxyContin, became addicted to it, and then overdoses, has a lifelong addiction, or dies, or the addiction matures into an illicit addiction like a heroin addiction, which I'll talk to you in a second. Dave Schweitzer and I had a claim similar to that. That can add to what would otherwise be an unpersuasive claim. So, in the claims, as the claim comes in, give you an idea as you do your claims triage of some things to look for that might suggest you have an opioid addiction problem in the case. Number one, does anybody happen to know what the most common side effect of an opioid addiction is? It's constipation. And it also just so happens that the pharmaceutical companies that manufacture most of the opioids also manufacture the drugs that treat opioid-related constipation. Small footnote. So as you're going through medical records, when the demand package comes in, if you see long-term treating opioids and there's also in the notes of diagnosis something about constipation, first clue. Second clue, because of all the liability issues stemming from the opioid dependency issues, doctors' offices are having patients sign dependency contracts. Has anybody heard of a dependency contract? It's basically a 2-page piece of paper that says, I, the patient, promise not to abuse the drug, and I, the patient, promise not to sell it or transfer it or do anything otherwise illicit with the drug. I'll use it for its intended purpose. If you guys are ever triaging a claim and you see one of those contracts in the medical records that the plaintiff's lawyer was dumb enough to not pull out before they sent you the demand package, that's the second clue. So keep an eye on those things because those are very common, very important issues to look for. I'm going to jump around a little bit so that I can get to the fun stuff. The demographic of claimant who might have an addiction isn't easily defined and is often amorphous, right? It's not the guy on top who can have the opioid dependency. It can be the woman on the bottom, basically. You can't typecast this type of person into one thing. If you've got a case where you think that there's a colorable opioid addiction claim and you're not sure what to do with it because you think the plaintiff's lawyer has at least convinced somebody for the time being they're smart enough on how to try that case, you've got some options. And what you need to have a conversation with your defense counsel on is, do we have an argument to keep all of that injury out on proximate cause? Proximate cause is the buzzword that breaks the causal chain from your loss to that injury and which can ultimately keep it out of a trial. And there's a little bit of appellate authority on it, but the most persuasive for opioids specifically actually comes to us by way of Judge Cherry over in Dauphin County. I don't know if anybody knows Judge Cherry. Tends to keep an unlit cigar in his mouth during a settlement conference, you would remember. Smart judge, and in 2011 did an incredible job handling a case that had these facts. Rear-end collision on Paxton Street, cervical sprain strain injuries, person has a valid prescription for opioids, she overdoses 4 months after the accident and dies, and a wrongful death suit follows. And Judge Cherry, in a very pointed and well-written opinion, basically said that that opioid addiction and that accidental overdose on the opioids was not admissible. And he goes through a great analysis of how proximate cause works, why there's no duty of any of your insureds to keep somebody from overdosing on their drugs, and why there's no proximate cause. So if that comes up and you're litigating that case, make sure you and your defense team are talking about proximate cause, because that will be your defense. I've got a copy of that opinion. I've got some other paperwork for what those contracts look like. So if anybody has any questions afterwards, please track me down. Otherwise, thank you very much for your time. And next up is Peter Bieberstein.
Hey, everybody. My name is Peter Bieberstein. I'm an attorney in our D.C. office. I am going to get this clicked over here real quickly. If anybody was at our May claims presentation, I talked about e-cigarettes and vaping then. Today, this is going to be a compressed version of a similar talk, but I'm focusing on some new issues that have been in the news, primarily all of these mysterious deaths and injuries you guys have been hearing about that have been basically just confined to this calendar year. So what I'm going to do is run quickly through the technology, what e-cigarettes are and vaping devices, how they work, touch on a new decision from the U.S. District Court for the District of Maryland that is going to provide some clarity finally in this uncertain regulatory environment, then talk about new risks with this, what is now called EVALI, which is a not very catchy acronym, and then I'll talk about other risks and how this all do the work you guys do. So starting out the technology, e-cigarettes and vapes, what are they? So they're called electronic nicotine delivery systems. And basically, what it is a heating element that heats up a liquid that turns it into an aerosol so you can inhale it and get that nicotine into your body. Now, they are used with what's called e-liquid, e-juice, vape juice. It is a combination of usually propylene glycol and vegetable glycerin with food additives and then nicotine. Now, they make them also without nicotine, but most of this is to get nicotine into your system. So the anatomy of the modern e-cigarette has basically all of the same components. A heating element or atomizer, a tank or a cartridge that you put that e-juice into, a mouthpiece, and these can be either manual or automatic. Vape juice or e-liquid, like I said, it's propylene glycol, vegetable glycerin, and then we don't really know what's in there beyond that. And part of that is because these things are not regulated at this time. So I'm going to pass around a box of what used to contain a bottle of e-juice in it, and you'll see it just says that it has food additives and vegetable glycerin, propylene glycol, and nicotine. The problem is some of those food additives can be pretty dangerous. I might need to switch mics next time. Okay. I was told to put it right up to my mouth. So some of these food additives contain things that are pretty dangerous, and they've not been approved for inhalation, only for ingestion. But there, like I said earlier, there are nicotine-free options. This photo here is from a vape shop, and as you can see, the amount of options are dizzying. So this is new technology, right? Well, not really. The first smokeless cigarette was actually patented back in 1963, and vaporizer technology goes back even further to 1930. Now, that is not a portable vaporizer, but these ideas have been around for a long time. It just took a big public health scare, or not scare, a big public health crusade, basically, to stamp out smoking to get the public to embrace this. So neither of these designs were ever brought to market. Both those patents have long expired. So now we've seen a trend, though, from what started out as being something that looked like a cigarette, called a cig-alike, then to a vape pen, which is basically the traditional model I showed in the diagram earlier, to then now the two primary things you're going to see are a box mod or a vape pod. Box mods are the thing on the left. Those give the user a lot of control over the way, the voltage, the resistance. I'm not going to get into a physics lesson here, but basically less resistance allows more electric current to flow in to the device, which can then heat up a larger amount of the liquid and lead to a bigger cloud. There are a lot of people that do what's called cloud chasing, and they just try to see how big of a smoke cloud they can blow. Vape pods are more common, and what those are is it allows somebody to open up a cartridge, put the juice into it. It's got a mouthpiece built in. It's less customizable but more easy to use. Everybody here now has probably heard of Juul. Juul is the 800-pound gorilla or the iPhone of vaping. I've got a Juul here I'm going to pass around. I have to warn everybody, don't use it, please. But you can see it's very sleek, looks like a USB stick, basically. Here, Roy. And that device has what's basically a disposable pod that's got e-liquid in it. That's what all the teenagers are using in class, after basketball practice in the locker room. It's very easy to conceal, and it's leading to a lot of the concerns about teen use right now. So Juul has been named as a defendant in several large lawsuits, and there are going to be plenty more to come. So vaping is a huge industry. In 2017, it was valued at about $14 billion. Or not valued at, sorry, that was the sales in 2017. The compound annual growth rate was projected to be about 20% from 2018 to 2023. Now, I think those rosy predictions need to be reevaluated in light of this summer. All these people are dying, and we don't know why. But it is still big, big business. I'm going to flip through the teen concerns there. So regulatory uncertainty has been the name of the game since these products became more and more ubiquitous, because the FDA has put off regulation for years now. So back in August of 16, they decided they were going to start regulating, but it might take 6 years or so. So Judge Grimm decided to put an end to that. So like I mentioned earlier, in the U.S. District Court for the District of Maryland, in this lawsuit, American Academy of Pediatrics versus FDA, he found that the FDA was violating the Administrative Procedures Act, and in July of this year, finally issued a memorandum opinion that provides some clarity. So it sets timelines for when the FDA has to actually start regulating the devices that are on the market. There are different rules for devices that were on the market in 2016, ones that had applications currently pending, or new products that haven't yet had applications filed. I actually put the opinion in the material, so if anybody wants to read it, it's interesting. But finally, we will have some guidance, which is going to be good for everybody, because right now it is a very murky area. So now I'm going to talk about E-Valley, which is e-cigarette or vaping product use associated lung injury. The CDC named it that about 2 weeks ago. The reason for that is because nobody knows what it is. So about 1,500 people now have been diagnosed with these strange lung conditions. They're presenting to emergency rooms across the country with similar symptoms to pneumonia, or with shortness of breath, coughing. A lot of them have gastrointestinal problems too, but none of them have any infection. So the doctors can't figure out what's going on, and the CDC can't either. All they know is that something's wrong, and the only common thread is that everybody has a history of vape use and is otherwise healthy. It's mainly targeting younger people, about 70% male. The other common thread, though, is about 78% have reported using THC-containing vaporizer products. Now, that number's probably a little on the low side, and that's because people don't like to admit that they're using illegal drugs. But they have not been able to rule out nicotine as a source, and they can't find any single common ingredient. So theories are that it's probably something to do with black market, illicit non-medical marijuana, and that it's probably not coming from dispensaries that are regulated, but we just really don't know right now. All we know is people are getting sick, and 33 people have died so far. Sicknesses are in every single state except for Alaska, also in the District of Columbia. So from a claims perspective, if you insure a vape shop or a corner store and somebody gets these kinds of sicknesses, you may want to look into what they've been doing in their spare time. Some other risks that I'm going to talk about are battery explosions, nicotine poisoning, underage sales and use, popcorn lung from diacetyl and acetylpropanol, and those are food additives that don't have to be disclosed, and then some workers' comp risks. So battery explosions, you may have seen this on the news. These are pretty rare, but very, very dangerous. 2 deaths so far that have been reported. Usually they happen when the device is either in use or in someone's pocket. If it's in use, obviously the potential for serious injury is high. Someone in Texas was killed by shrapnel into his neck when it exploded during use. About 62% is in use or in pocket. Now, this is usually because of the batteries either having static electricity buildup or some sort of short circuit in the device or other quality control problems, which goes back to some of the regulatory issues that need to be ironed out. Is right now there are no guidelines for manufacturing these devices. The vast majority of devices are manufactured overseas, and there's not really a process that's clear yet for how the manufacturing is going to be regulated. So short circuits, the current from that can be generated by static electricity, and then the other things that are going to be useful for you is if you see a property claim where somebody was charging their vape overnight under the bed and it starts a fire. That's a violation, or not a violation, but that is against the manufacturer recommendations. So pay attention to that, especially if it's a tenant you might be able to subrogate against if it's a commercial property. People are going to use their iPhone charger or some other charger that's not rated for the voltage on the actual device. All of these devices have rules that are printed on the terms of use. I've got a device here I was going to pass around, but I think for time we're not going to. But people aren't following the written recommendations of the manufacturer, and that's something to keep an eye on also. FDA had a symposium on battery explosions in 2017, so you know it's been on their radar. Unsurprisingly, nothing really came of it, but they did issue some guidelines on how you can avoid these problems. Lack of safety features is one common thing. Carrying the batteries in your pocket, not properly charging, not following the recommendations. And then I added on there mechanical mods and tinkering, because there are a lot of people that like to buy interchangeable parts and put these things together themselves that don't have training in engineering, don't have training in physics, but decide they're going to build themselves a vaporizer. Not a smart idea. Nicotine poisoning, I'll just go through quickly. That is something that has spiked over recent years. The CDC's got lots of numbers on these, but basically EMS or emergency rooms across the country have seen a lot of people come in with nicotine poisoning. That graphic at the bottom shows from 1 month back in September of 2010, one report. A few years later, same month, 215. So it's increasing. And 42% of those calls are for people that are over the age of 20. The vast majority of the other ones, over half of them, are children under 5. So I've said this before, but it's kind of the strange irony that the only people that seem to be able to safely use this nicotine are the teenagers that aren't supposed to be using it. But it's not just overuse. Skin absorption, leaky pods, that goes back to problems with quality control. It can also be spills. If you have something in your purse and it breaks or spills open, and then you reach down to grab your keys, you might be able to absorb it through your skin that way. But there's not much data out there yet as to how much is needed to give someone nicotine poisoning. And obviously the user, it's going to vary depending on if they have a tolerance. Underage sales are another big area that's been focused on for crackdowns. Secret shoppers, states are passing laws. There are federal efforts that haven't yet become effective, but they're trying to get rid of all flavored sales except for in vape stores, because the theory goes that flavored tobacco products or flavored nicotine products are targeted toward children. That's something else to be wary of. If you're insured has these products that they're selling, it's good that they would have something in place to make sure they card everybody, something like that. Popcorn lung. This is something that's pretty scary. This is likely to be the most common cause of comp claims in the short term, I think, because people can get exposed to these chemicals and never be a smoker or a user themselves. It's called popcorn lung because diacetyl is a commonly used food flavoring that was used in microwave popcorn. Earned this name because people that worked in the factory started getting this disease, and it's called bronchiolitis obliterans. Nobody could figure out why. Well, it's because they were inhaling this food flavoring, and it gave them a severe irritation of the alveoli, which are the smallest little airways inside your lungs, and it leads to really serious long-term problems. Popcorn lung, unfortunately, is going to get more and more common because diacetyl is in almost every batch of these e-liquids. And they don't have to tell you about it. Again, they call it a food flavoring, which is true, but it's not written on the product itself. So a lot of the manufacturers do have information on their website where if you go look, you can see the lab tests, but they're not required to do so. So I expect that workers in some of these factories are going to start making popcorn lung claims because they're going to be exposed to it. Some other workers' comp risks are what happens on a cigarette break. There was a reported case from last year in North Carolina. A supervisor, Mr. Larry Brooks, went out with some of his coworkers to go buy smokes at a corner store. He bought an electronic nicotine delivery device, takes a big pull off of it, passes out, hits his head. So he makes a claim. Claim was denied as being an idiopathic fall, which is not a comp lawyer here, but I think that means it's not something that arises out of the work environment. But it was denied, and that denial ultimately was upheld on appeal. Some other comp risks that might happen, though, would be: are people using these at the office? Are someone spilling their e-liquid on their coworker? A smart policy would be to say you can't use these devices at work. Lastly, going into some specialty policies, if you go and Google vape policies, lots of new carriers are popping up all over the country that are writing policies specific to the risks posed by vaporizers. But there are also claims that are being made against CGL policies. These haven't been tested much yet, but there is a case from California that I listed up here, which is United Specialty Insurance Company versus e-cig Vapor Emporium. And that's a DJ action where the carrier didn't want to pay to defend or indemnify because they had a products completed operations exclusion, which most CGL policies are going to have. This person had purchased a vaporizer, gone off the premises, was using it as they were supposed to be, and they got injured and tried to make a claim under a CGL policy. The courts ultimately sided with the carrier and said no duty to defend or indemnify based on the policy language that they found to be clear and unambiguous. But that's something you always want to look into your policy whenever you get a claim. But these are things that are basically changing in real time. So all I can say is, if you get a claim involving vaporizers or e-cigarettes, you probably want to pick up the phone and call defense counsel and talk through some of these issues after you look at your policy. But they are new issues, and we're going to see more and more of them. So keep your eyes peeled. I think that covers it. So if anybody has any questions, you can shoot me an email, give me a call. I also have a longer talk about the same subject that's available on our website. Thank you. Oh, and Rebecca is... Okay.
Okay. Rebecca Sember-Ejak is on the phone and too busy to talk to you folks right now. She's actually on the phone with a federal judge. It's a status conference. So what we're going to do is we're going to take our break early, and Rebecca will do our presentation after break. So let's take 10 minutes now. Okay, we can have a vote. Or I can do a song and dance. That sounds like the break has it. I could do a break dance.